need to postpone our scheduled May 4th hearings on such short notice, but I appreciate your accommodation and your cooperation in rescheduling it so promptly. These hearings will be conducted virtually through this Zoom platform. I want to again extend my appreciation to Joe Stanton, our incomparable clerk, and his team for building this platform with the live stream to a YouTube channel for public access. It allows us to continue doing our business almost as usual. You will see that there are a few things that are a little different. We do not have the red, yellow, and green lights on the timer, but we do have a timer that will appear once the arguments begin in the upper left-hand corner where the seal of the appeals court currently appears. The rules otherwise are the same. Each side of the V has 15 minutes to argue. If more than one attorney is arguing on either side of the V, we ask that you let us know ahead of time how you'll be dividing your time, and there is no rebuttal. We are familiar with the arguments that you've made in your brief. We're familiar with the factual and procedural background. You needn't restate all of that, and we will have questions for you. If you've reached all of the points that you feel the need to make before the end of your time, you needn't continue to argue. Conversely, if you run out of time before you finish your arguments, don't worry. We have the arguments you've made in your brief, and you can rest on your brief. With that, I will call the first case on our list, case number 2019 P1327, Ryan DELLORUSSO versus PNC Bank, N.A.
Good morning, Your Honor. This is Nicholas Ortiz representing the appellant. May it please the court. There are two laws that govern the transactions that we are here today to discuss. As the court knows, the UCC governs all secure transactions of personal property. The Retail Installment Act, that I'll be referring to as RISA throughout the course of this argument, applies to the business, the particular business that the defendants are in, namely the credit sale of cars. Both statutes work together, and they have a mechanism to do so in Section 20B of the RISA that we are referring to in a sort of shorthand as the displacement language. It says that any contrary provisions in the UCC are displaced by those in the RISA for those folks that are, for those businesses operating in the retail credit sale of cars space. That distinction is an important one, or rather, maybe not distinction, but the existence of those two laws is an important one because the way that deficiencies are calculated under both laws differs. Under the UCC, a commercially reasonable sale yields sale proceeds, and those sale proceeds are applied to the debt of a consumer, of a debt of a debtor, frankly, any debtor, in order to reduce the amount that's owed for the deficiency. The RISA provides that consumers engaged in retail credit sales contracts of motor vehicles have the benefit of a fair market value credit.
Mr. Ortiz, I'm sorry to interrupt, but I want to, I guess, cut to what I think may be the central question that we have before us in this appeal, and that is the question of whether the Williams versus American Honda holding applies retroactively or only prospectively. Isn't that the main issue that we have to decide in this appeal?
It is, Your Honor, and I'll jump right to that. The general rule of statutory interpretation really has two aspects to it. First, there's the explicit one that says that statutory interpretation by an appellate court goes back to the date of enactment. That flows from important principles, including separation of powers and equal protection. And there's a second principle there that's explained in cases like McIntyre, which we cited from the SJC. It says that when the SJC is silent on the issue of retroactivity or prospectivity in the case of statutory interpretation, that has substantive import, which means that the SJC must tell us so if it wants to limit a holding, because if it says nothing, that silence means something, that it goes back to the date of enactment. And That's especially true here, where the defendants in the Williams case asked the court to limit its holding, and the court declined to do so. But exceptions are made. And
did they decline to do so, or did they just decline to answer that question because it wasn't necessary?
Well, there was a petition for rehearing that raised just that question, and the court denied the petition for rehearing. So I only use as an example to say that the court had the opportunity. It did not slip the court's attention. But even without any of that, the silence in the opinion itself as to retroactivity has legal import, has legal effect. We submit.
Are you aware of any case in which the SJC was silent in its initial statutory interpretation opinion and subsequently announced that it would apply that statutory interpretation prospectively only?
It did so in Shapiro versus City of Worcester. In that case, the issue was whether or not a plaintiff had to present when suing a municipality for private nuisance. In 1987, and this is all discussed within Shapiro, what I'm about to say. In 1987, the appeals court in Azalea said you do not have to present. In 2010, the SJC and Morrissey said you do have to present. In Shapiro, the plaintiffs filed their case in 2008, 2 years before Morrissey was decided. And so the SJC and Shapiro essentially found that to be the type of extraordinary circumstance that would warrant this sort of analysis that I'm sure we'll conduct here today, and actually a ruling that that law was not going to be retroactive for those people that filed cases within the statute of limitations before Morrissey, the 2010 case, was decided. And that question, Your Honor, is a critical one because it helps to highlight when it is appropriate, when there are extraordinary circumstances.
In the Shapiro case, what did the trial court judge do?
I believe, and this is coming more from my recollection than from a certainty, but I believe that the trial court judge found that it was not retroactive, meaning that the SJC ended up agreeing with the trial court judge. But I don't have that before me right now. That's my recollection. And that's the best answer I can provide without using too much time at this juncture. I'll note too, though, that when we do talk about what are extraordinary circumstances, it all is premised on a new rule. And we see that very clearly. We had an Azalea rule, an 87 rule, and we had a 2010 rule in Shapiro. Here, that we don't have a circumstance like that. All we had prior to the DELLORUSSO decision, was the Williams litigation. Excuse me.
Well, you suggest it's not a new rule, right? Because
right. Thank you, Your Honor. I lost my train of thought.
Okay.
It's not a new rule because all we had was the Williams litigation and the statutory text itself. Now, we'd be in a different universe, perhaps, a different type of discussion if we didn't have the displacement language. But as the court, we filed a letter notice pursuant to this court's rules with a decision out of the U.S. District Court of Massachusetts. And I think that court explained it well in the sense that if we have ambiguity and disagreement regarding a statute, well, that's the type of situation that does reach this court or does reach the SJC. And if we really take defendant's argument or appellee's argument here, that this sort of uncertainty should be the type of extraordinary circumstances that give rise to this kind of inquiry, and moreover, not just the inquiry, but an actual finding on the part, for the defendants in this case that the law is not retroactive. If we consider that, it just doesn't end up making any sense, and it swallows the entire rule. We don't have a situation where a court told, or there was some other authority said that it's X, and then it's going to be Y, and then plaintiffs or other parties relied on that. And we cite cases,
But Mr. Ortiz, as a practical matter, what would your client have done differently if the notice had complied with the UCC? Right? His car was being repossessed one way or another.
Right. It's not, we don't have to prove reliance. The statute triggers liability on the sending. It's a requirement of the statute that the
So what
notice.
is the practical ramification of that to your client? That's what I want to understand.
The practical ramification is if they get their car repossessed, if my client gets his car repossessed, he can go and look up what the fair market value of the car is and get some reasonable idea of what type of debt they may be looking at in the shrinking 20-day window to either redeem, surrender, or take some other action with respect to the car. And they'll be able to have the type of transparency that the statute was designed to promote. Because
and it would have caused your client to do X if he had that. What's the X?
Well, I cannot say that my client would have taken, a particular action, but his calculus that he would have done to make the decision about redemption or about letting the car go, that is a decision that hinges very much on the amount of the deficiency debt that you'd be looking at if you let it go. Because if you let it go ahead.
And do we know on this record what the number differential was?
That is not something that's in the record. No, Your Honor.
Then when you say let it go, are you suggesting that he could get the car back at fair market value as opposed to the debt that he contracted for?
No, he could get the car back at the debt that he contracted for, but his knowledge about what he would face if he let the car go, if he didn't use that 20
I see what
days.
you're saying. Okay, I get it. So you're saying that if knowing that you might have a large debt looming, you might say, I'd rather keep the car and try pay off the debt. Knowing that it might be a little debt looming, you're like, you know what, I'll let it go and just. Is that what you're suggesting? Okay.
That is what I'm suggesting, Your Honor. It ultimately, the decision to either redeem, to reinstate the debt, or to let the car go during the shrinking 20-day window after repossession is a decision that should be taken and was designed to be taken with the type of information that the statute intends. And,
Okay,
sorry.
I understand that. So let me ask you this. I mean, you seem to suggest, one of the things you suggest is that the fact that other dealers were already providing proper notice suggests that there wasn't real ambiguity in the statute. But doesn't that actually suggest that there could be different interpretations, and until Williams, it wasn't properly interpreted?
Well, I would submit, Your Honor, that in light of the displacement language, it was not reasonable to make the interpretation that the defendants did in this case, because what Section 914 of the UCC states is that creditors have to describe the basis of the deficiency. The exact language is a description of any liability for a deficiency of the person. So in order to do that accurately, because the description, to be a description, has to be accurate, it has to be noted that there will be a fair market value credit instead of what a dealer may fetch for it at a dealer auction or a private sale that's potentially in the consumer mind or maybe in reality collusive. Those are the sorts of credits that would cause a consumer reasonably to think that, hey, I'm going to get a small credit for this. I'm going to be facing a big debt, and I'm going to take some action to rob Peter to pay Paul, essentially, to get this car back.
Mr. Ortiz, when we're looking at sort of the exceptional circumstances to justify departing from the rule, the third prong of that is whether application is required to avoid inequitable results, injustice, or hardships. And I certainly expect that Mr. Volk is going to tell me that that is applicable here. Can you address that point?
Right. I think that, again, it goes back in many things in our argument feed through that displacement language, in the sense that it's not unjust or inequitable because the defendants had notice of this displacement of their particular business. That's number one. Number two, to the extent that there's ambiguity of interpretation, and we presented some examples of creditors that did it right, that is the sort of thing that we're always going to see, or usually going to see, when a case reaches the SJC. And the assignment of risk, is a reasonable one, because it encourages, by doing the normal interpretation of this law, because it encourages people to try hard to interpret laws right, before, when they're enacted, which is the intention of the legislature, and before a court, maybe 10 years later, comes along and makes a ruling. Not only that, it encourages plaintiffs to bring lawsuits because their case, like this one, isn't thrown out because this law shouldn't be retroactive, and that leads to the clarification of statutes. And
Mr. Ortiz, before we run out of time, I noticed at the end of your brief that you made a request for appellate attorney's fees. On what basis do you believe that you're entitled to an award of attorney's fees as the appellant?
Your Honor, I think that I believe in this case, we removed the 93A case, the 93A thing. Let me just take a quick look. I believe that that's the case. I just want to confirm that before answering it. But assuming that, we would not have a basis for that request.
Okay.
But I need to take a quick look here, just to confirm that limited time window that we have. Oh, it looks like we have a violation. We have a count violation of the Massachusetts Consumer Protection Act, and that would be the basis.
Okay.
And you're not proceeding from the dismissal of the class, right? This is just as to Mr. DELLORUSSO.
That's correct, Your Honor. No certification issues have yet been raised.
All right. Thank you very much.
Thank you, Your Honor.
We'll hear from counsel for the appellee.
Thank you, Your Honor. I first want to point out that we, in fact, did have some precedent that creditors could go by as far as interpretation of the potential conflict between RISA and the UCC. And that would be Judge Sorokin's decision in July of 2014 in the Williams case, in which Judge Sorokin dismissed the claims of Williams on behalf of Honda, finding that Honda's reliance on the safe harbor language of the UCC was proper and adequate. So if we want to look to what precedent was out there for creditors like PNC to follow, that was the only precedent commenting on any apparent conflict between RISA and the UCC.
But that was pending on appeal.
Yes. But as far as any court having addressed the issue, Your Honor, that was Judge Sorokin's decision in that case.
But that's true. I mean, in any instance where you've got where you've got retroactive application of a judicial statutory interpretation, you either have silence or lower court decisions that are pending on appeal. The rule is still the rule.
Yes, so the point I'm looking to make with that, Your Honor, is that as far as ambiguity goes, and ambiguity, I think, is the key here. We had ambiguity as to whether RISA displaced the UCC safe harbor language. And the U.S. District Court and the First Circuit both determined that there was, in fact, ambiguity. This is the same ambiguity which my brother contends PNC and other creditors were unreasonable to point out or to say there was ambiguity and to use the safe harbor language of the UCC when apparently it was obvious that it was displaced. Well, the two courts looking at this prior to the Supreme Judicial Court looked at it, determined that there was, in fact, ambiguity. Well, in fact, Judge Sorokin determined there wasn't and ruled in favor of Honda in the first.
That would go, it seems to me, to the question of whether the creditor can be held to culpability on a claim of bad faith, but not to a question of what how their rights should be determined based on the statute, the application of the statute.
Well, if we're applying Eaton, Your Honor, ambiguity comes right into play.
Eaton was a case in which the SJC within Eaton itself established a carve out from the retroactivity rule.
Yes.
And I guess one of my questions as I'm looking at this is whether we, as the appeals court, are the appropriate party to make a determination of what the SJC did or didn't do concerning retroactivity.
Well, I think the decision is more as to what the Supreme Judicial Court would do rather than what they did do.
Well, let's take what they did do. They did not announce that it would be an exception to the general rule. When invited to address that specific question, they declined to take it. When a Superior Court judge expressed his view that the Supreme Judicial Court really meant to, they did not exercise their authority to take this case for direct review sua sponte.
Well, Your Honor, I might disagree with what the Superior Court judge did. I don't believe that the Superior Court judge decided what the court meant to do. I think the Superior Court judge decided what the court would have done had it addressed the issue.
Okay, that distinction in the formulation is noted, but the point is the same. The Superior Court judge framed this precise question, expressed his view, and while that case was pending here, the SJC has a group of attorneys who comb through our pending cases to determine which cases they think they should express a view on. They left that with us. I mean, I realize that none of those facts is dispositive, but despite multiple opportunities for the SJC to declare their view that this is an appropriate case for an exception to the general rule, they have so far declined to do so. And yet you're asking us to do so instead.
Let me address that in two parts. First, with respect to the certified questions to the SJC, the SJC answered only the questions certified. Retroactivity was not a question certified to the SJC, and as is their history, they generally rule only on the questions that are certified. And I think this is different from a case that comes up through the state courts and gets to the SJC, and they examine the entire case, not just the questions that are certified to them.
But surely the question of the proper interpretation of the statute, they recognize that their answer to that certified question would have implications for future cases involving that statute.
I have no doubt, Your Honor. And actually, I may address Your Honor's other point, which I think is well taken, in that the court did not decide to take this case up on its own. And as you say, they have lawyers who look over these cases. I would think that's something that is positive for PNC, in that if the SJC had determined that the Superior Court had done something wrong, that the SJC would more likely take it up on its own rather than leave it to this court. I
can't speak for the SJC. It seems to me that if they saw that there was a question that required an answer about retroactivity, they would view this as the appropriate case to do so. Again, I'm left with the question whether it is even a proper role for the appeals court as the intermediate appellate court to declare that this statute, or that Williams does not have retroactive effect in the absence of guidance from the SJC on the topic.
Well, I expect that the SJC had full faith that this court would go along with the Superior Court. And
no, let's parse that a little bit more closely. I mean, what is it that the SJC thought we might do when they decided that they would leave this case here? Because if your suggestion is that they would expect us to act on their behalf to state the retroactive or prospective effect of their prior decision, that strikes me as kind of an odd expectation.
Perhaps not, Your Honor. But I do believe that if the SJC is applying precedent in the Eaton case and in Pinty and in American International versus Robert Sufer, that if it applies their philosophy, if you will, as to retroactive versus prospective application of statutes, I think this is exactly the type of case.
You think that,
No,
but the SJC, I'm sorry, the SJC in each of those cases made that calculation and made that declaration within that decision itself. None of them is a case like this. And your brother, when I asked him the question, I identified the only case that I'm aware of, the Shapiro case, in which the SJC circled back at a later point and made that determination. I did look through the procedural history, and it is correct that in both of those cases, the trial judges, the motion judges, I should say, had done what the motion judge did here, and suggested that the case ought not to be retroactively applied. But in both of those cases, the paired cases, Shapiro and Greenberg, the SJC took those cases directly for the purpose of expressing its view on the point. I'm left once again with the odd situation that we find ourselves in here, with you asking us to declare what the SJC would have done if they had addressed the point in Williams, when they've rather conspicuously declined the opportunity to do that now on 3 occasions.
Well, I think actually, if I might carry that point over to the First Circuit, the First Circuit is generally left with interpreting what the SJC may do in certain circumstances, and it generally doesn't certify questions unless that is in doubt, unless there is ambiguity. And the Superior Court was left to do the same thing, but on a different issue, retroactivity. But state courts, federal courts are asked all the time to interpret what the SJC might or might not do, what they would do if they were presented with the issue. And I go back to the SJC's decision not to rule on the issue when asked to, but they simply denied the petition. They didn't comment on it. They didn't rule on the merits of it in any way, shape, or form. Why? I expect, and I think the Superior Court judge addressed this, because they weren't asked to. It wasn't part of the certified question, either any of the 3 certified questions that were posed to the court.
Mr. Volk, what is the practical effect to somebody like, or an entity like PNC Bank, if it is applied retroactively?
Well, what's applied to PNC and creditors like it is that they are being penalized for acting in good faith. There was no motivation for creditors like PNC to use the safe harbor language that they thought in fact was safe. They didn't gain anything by it. There was no motivation to opt not to use a notice that has the safe harbor language that the SJC issued in the Williams decision going forward. And so they couldn't adopt that language because it didn't exist. The SJC's language that it issued in Williams that creditors should use going forward was not available to creditors prior to the Williams decision.
Mr. Volk, let me just ask, I mean, that may go to the remedy, but not the interpretation of the statute. Let me just ask, and I should know the answer to this, it didn't occur to me to ask the question until just now. Did you or Mr. Ortiz apply for direct appellate review in this case?
We did not, Your Honor.
Mm-hmm.
We did not. And I want to point out just quickly language from the SJC itself in the Robert Sufer case, which I think is very instructive. And it speaks of ordinarily our holdings apply to past as well as subsequent transactions. Nonetheless, it is sometimes necessary to depart from the general rule of retroactivity in order to protect the reasonable expectations of parties. And when a decision announces a new interpretation of a state statute, we are free to determine whether that holding should be applied only prospectively.
Is it a new interpretation if there was no interpretation before?
Well, the new interpretation isn't, in this case, of a statute. It is an interpretation as to what
A practice.
effect one statute has on another. I think it should be pointed out that the UCC was adopted in Massachusetts 5 years after RISA was put in place. So you had RISA in 1996, and then you had the UCC adopted in 2001. And this safe harbor language is adopted in 2001 by the legislature. So, certainly there would have been an opportunity to carve that out and say, well, this doesn't apply to repossession of automobiles.
So does that mean that before the adoption of the UCC, auto dealers were using the language from RISA, being more specific, and then they changed when the UCC?
No, well, the point is that the safe harbor language came into effect, Your Honor. And so in 2001, creditors are told, look, now you can use this safe harbor language for repossession of collateral. It's now been said, well, that didn't apply to repossession of automobiles because of RISA. But,
But doesn't that go against,
my brother
I
had
get the
six-
timing,
my
what
brother
you're
had
saying about
six
the
other-
timing, but actually that kind of goes against, the good faith, because if prior to that they were having these notices that gave fair market value because that's what they were doing, what really RISA said, and then all of a sudden but you know what, we can stop that now because we got this, we can now use this other thing. That actually, doesn't that go against your good faith argument?
No, I don't believe it does, Your Honor. The UCC was still out there as instruction to creditors across the country. And so it just wasn't formally adopted by Massachusetts until 2001. But certainly the laws in the UCC, Article 9 in particular, and the treatment of collateral and the repossession of collateral were all out there. But Massachusetts in particular adopted that safe harbor language in 2001. And then we have Williams many, many years later, where a court finally says, well, we know it was supposed to be safe, but it wasn't really safe. And you shouldn't have been relying on it. But plenty of creditors were, as is demonstrated by the fact that my brother had 6 class actions going in Massachusetts against various lenders. And I believe in his brief, he cited an example of 2 in which someone luckily used different language. And
Thank you, Mr. Vogel. I see that your time has come to an end. That will conclude the argument in this case. The case is submitted, and we will turn to the next case.
All right, we are live.
Okay. Our next case is case number 2019 P329, Wells Fargo Bank NA versus Joseph Cavaliere. The procedure here, even though we are doing this hearing virtually remotely, is very much the same as it is in court. Each side of the V has 15 minutes to argue, and there is no rebuttal. We are familiar with the arguments that you've made in your briefs and with the record and procedural history of the case. You needn't recite all of that. If you reach all of your arguments before you run out of time, you are free to conclude. If you don't reach all of your arguments before you run out of time, you may rest on your brief. There will be a timer that will display where the appeals court seal currently appears once you begin arguing. It is different from the digital timer that we have in the courtroom. There are no lights to prompt you when there's a minute and a half left, but it does count down from 15 minutes to 0. And when the time expires, you will see a prominent red card that appears letting you know that fact. With that, Mr. Patterson for the plaintiff bank.
Thank you, Your Honor. May it please the court. I am here today on behalf of plaintiff appellant Wells Fargo in connection with its appeal of the entry of summary judgment entered against it on its possession claim in the Northeast Housing Court. While there are discussions of other discovery motions and claims in the briefs, I want to start out by being clear that the only decision on appeal is the Housing Court's decision to not only deny Wells Fargo's affirmative summary judgment motion on the possession claim, but also award summary judgment on possession to defendant borrower, even though Cavaliere did not formally move for summary judgment.
So you're not suggesting then that there is an issue of material fact and the case should be remanded for trial, you think as a matter of law, you should have been awarded summary judgment?
I do think there are two arguments, Justice Blake, that we make. One is, and I'll get right into the primary argument or the primary problem we see with the ruling on the conduct of the foreclosure sale, specifically how it relates to the highest bidder and also the borrower's best interest statute. We do believe that we submitted a proper prima facie case with the certified foreclosure deed and the certified affidavit of sale. At that point, we believe Mr. Cavaliere would need to present admissible evidence to show, not merely to suggest that there could be a problem with the process, but to show evidence that there was a problem with the process, both with regard to the foreclosure sale and the identity of the bidder, and also with regard to the borrower's best interest statute. It's our position that the interrogatory responses and the loan notes that he relied on allegedly to rebut the prima facie case, he argues that those are inadmissible and cannot, because they contain third-party hearsay. Well, if they're inadmissible to support our summary judgment, they would also be inadmissible to rebut at the summary judgment stage the issue. So we would submit that on both of those issues, and with regard to the borrower's best interest statute, there was no evidence presented on the 5 factors that the statute lays out with regard to interest rate, cash out, monthly payments. I mean, none of that was in the record. In fact, the borrower's best interest statute wasn't briefed at summary judgment. It was briefed in the context of a discovery motion, which is not before the court today.
My understanding of Mr. Cavaliere's argument is that as to the interrogatory responses, where we are in reviewing the judge's order here is in core vacilis territory, right? The question is whether the non-moving party can demonstrate that the moving party has no prospect of satisfying, of establishing an essential element of its claim at trial. And I think his argument is that by saying that there was no one known to the bank who has personal knowledge of the relevant facts, that admission was an admission that the bank cannot make its necessary showing at trial.
Yes, and that's sort of point 2 is, if the court concludes that the interrogatory responses and the loan notes are sufficient to rebut the prima facie case, then you have a situation that the court itself recognized is, quote, contradictory evidence, which would have to be resolved at trial. And the quote, Your Honor, that you just referenced, I want to be very clear, because at page 30 of his brief, Mr. Collier says Wells Fargo stipulated that, quote, it did not know the name of a single Wells Fargo agent or officer or employee who contacted a single bidder. I think that's what you were referring to.
Yes.
If you look at the record, volume 3, page 403, Wells Fargo didn't say that. Mr. Collier said that. That is a quote from Mr. Collier. There's no way you can take a quote that Mr. Collier said at a hearing and say that that's an admission or a representation by Wells Fargo. The only thing Wells Fargo said is, we don't have a document. We didn't confirm in a letter or an email, a document that could be produced in response to a request for production, the contact. But certainly, if the court denied our summary judgment and we went to trial, we could call the bidders themselves as witnesses. We could present them to bene esse deposition. We could call the auctioneer. All of those things would be open to us. And that's really the second issue, getting back to the first question about, are we entitled to judgment as a matter of law? We do make that argument. But if that argument is somewhat debatable, the argument that I do not believe is debatable is there is no basis upon which Mr. Cavaliere could be awarded summary judgment on those 2 issues. At the very best, he presented some evidence to create a question of fact with regard to who the highest bidder was and the bidder amount, and we should have been allowed, as Wells Fargo, the case would go forward, and we may have to call live witnesses. We don't have to prove all of our case through documents alone, as it seems that my brother is suggesting.
So let's go back to the question of the sufficiency of your prima facie showing, because one of his primary contentions is that the affidavit was not based on personal knowledge.
Well, and I don't believe that that's a requirement under Hendricks and Gabriel. And I don't want to sound like I'm dancing on the head of a pin, Your Honor, but it depends on how you define personal knowledge. I don't believe personal knowledge is defined as you have to have the person who was at the auction, who actually conducted the auction, have personal knowledge. It's certainly acceptable in courts throughout the Commonwealth that personal knowledge for a corporate defendant can be provided by reviewing the business records and the documents that show what happened. The affidavit of sale here, which attests to actions that were taken by several either employees or agents of Wells Fargo, it is based on personal knowledge of Ms. De Silva, who works for Orleans Moran, and her reviewing the auction notes and the record. And I think that's standard. I don't think that's unusual with regard to affidavits of sale. I went back and looked, I believe it was the Gabriel case today, that Fran Nolan, a good friend of mine who works at Harmon, had signed an affidavit of sale in that case, which the court accepted. I know Fran Nolan is not an auctioneer. He would not have been the one that did the auction. So I don't think that defeats the prima facie case in any way, shape, or form. I think personal knowledge means you have to have personal knowledge of the facts gathered either through document review, talking to witnesses, or taking appropriate action. In other words, you can't have somebody sign an affidavit that hasn't done the work to gain personal knowledge.
Was there any effort to have affidavits from the bidders that were unsuccessful, numbers 1 through 4?
Well, there was an effort. As you might imagine, the bidders don't want to get involved in litigation.
Sure.
These are third parties that show up and bid, and when, frankly, the top 4 bidders, when they found out this was going to be challenged, said, we don't want to close. We don't want to get involved in litigation. And if it probably, again, getting back to the point I made earlier, that while we didn't have a document, if Judge Kerman had denied summary judgment, the case went to trial, we probably would have had to subpoena the bidders. And either if they were unavailable, we would have had to do a trial deposition and present their testimony that way, or subpoena them to come to trial. And because you have to understand, these are not in any way affiliated with Wells Fargo. I mean, these are bidders, and they say, I'm not going to voluntarily do anything. And so we would have had that opportunity. And that's what I think is procedurally unfair to us. I don't understand how the court denies us that opportunity. It's one thing to deny.
As a practical matter, whether if we affirm the summary judgment or you had a trial and the result was the same, what precludes Wells Fargo from reinitiating eviction proceedings and having a new bidding situation and a new auction?
Well, we couldn't reinstitute eviction proceedings without doing a new foreclosure, because if this decision is allowed to stand, the decision basically says the foreclosure was bad. You've got to do it again. So we would have to do a new foreclosure and then conduct a new eviction proceeding, which, this loan hasn't been paid in 10 years. That would probably build another 1.5 years into the process. And so, and I'm very sympathetic, especially given the current situation, to financial difficulties. And so I don't want to make light of that, but I mean, this is a very old loan that hasn't been paid in an extremely long time. And again, we can debate the prima facie case and whether we should have gotten summary judgment as Wells Fargo. What I don't think can be debated, though, is Judge Kerman's decision sua sponte to award summary judgment to the defendant when we should have been allowed to present evidence in the form of live witnesses at trial, or, like I said, through deposition testimony. I touched on it earlier, but the foreclosure issue, which we've talked about with regard to the highest bidder, but the borrower's best interest statute as well. There is a suggestion that Wells Fargo did not, in discovery, produce what's known as an underwriting worksheet, and that somehow is fatal to any claim that Wells Fargo could make to support that the loan was not violative of the borrower's best interest statute. That's simply not correct. The joint appendix in volume 3 at page 262 and at volume 1, pages 417 and 418, both of those, one is Mr. Collier's brief and one is our brief below. And again, this was briefed in the discovery motion. We cite the bait stamp of the underwriting worksheet. I mean, this is the underwriting worksheet, bait stamp 7802 through 7805, which was produced in discovery, and it lays out the cash back that Mr. Cavaliere received, the reduction in interest rate, the reduction in monthly payments. Those are all factors which support a finding of being in the borrower's best interest. The statute itself says no one factor is determinative, pro or con. In other words, it's sort of a totality of the circumstances. I certainly know, and I've litigated against Mr. Collier long enough to know that He will vehemently dispute that those factors are correctly looked at and that they should have looked at other factors. And that's perfectly fine. But you can't say we didn't produce a worksheet and therefore we lose the case automatically. If he wants to retain an expert or an accountant to challenge what's in this worksheet showing the benefits to the borrower, that's fine. Then we would need to go to trial, and Wells Fargo, again, would call its underwriter to say, this is how I looked at the loan. This is what benefits I think it had to Mr. Cavaliere. And Mr. Collier could call somebody saying, I think those benefits are grossly outweighed by the length of the loan or the interest rate or how it operated. I mean, that's what trials are for.
Mr. Patterson, you also make an argument about the effect of the bankruptcy discharge.
Yes, I do, Your Honor. I don't think that's our strongest argument. I'll be honest with you. I do think, though, this is important about the bankruptcy discharge is, again, it's one thing to say Wells Fargo is not entitled to summary judgment on that, because the case like Hollander is one of the key cases that talks about it's usually a fact-intensive inquiry to figure out whether there was good faith or bad faith. I don't think it's an issue that's subject to summary judgment. I think there would be, and we didn't really move for summary judgment on that issue. It was raised as to whether or not certain claims could be raised, but at the end of the day, I think it's a fact-intensive inquiry that is not really sufficient for summary judgment treatment, and so I would ask that would be reversed. Similarly, as my time is getting short, let me just touch on the one other issue, the class action settlement. And I want to be upfront with the court that I think if you reverse on the foreclosure and or the borrower's best interest, the case may need to be remanded for further proceedings. The settlement agreement really deals more with the remaining counterclaims, which have been severed and are pending in the trial court. The settlement agreement doesn't necessarily affect the prima facie case or the defenses, but the problem that I have with the court ruling on that issue is I don't want an argument of law of the case. Well, the judge has already ruled that you breached the settlement agreement, and therefore all my counterclaims can go forward, which are proceeding in discovery now, subject to the COVID limitations, but are proceeding in discovery. As a matter of law, the record, there is no possibility that as a matter of law, the court could conclude that Wells Fargo breached the settlement agreement. The two suggestions made are Wells Fargo didn't give enough notice to Mr. Cavaliere and that it didn't give him a written notice of denial. With regard to notice, the Northern District of California, who ruled over 500,000 loan claims in his class action, in its final approval order said the notice given, which was done by U.S. mail, by publication on the internet, and USA Today, was the best practical means of informing class members of their rights in the settlement's terms. That's a binding decision of the Northern District of California, who had jurisdiction over this case. You can't come in now and collaterally attack that and say, well, I think Mr. Cavaliere should have gotten an email or a phone call or something beyond what the settlement agreement said and what the final approval order approved. Similarly, Mr. Collier suggests in his brief that and it's unclear because the judge didn't really explain how he thinks Wells Fargo breached, but Mr. Collier—
Is Mr. Collier still in the room?
Okay. Mr. Collier suggests that, well, there was someone who applied for a modification during the class action settlement period was entitled to written notice of a decision if they were denied. But of course here, Mr. Cavaliere doesn't allege that he applied for anything during the settlement period. So it can't be a breach of the agreement that we didn't give him a written denial when he never applied. Wells Fargo can't force someone to apply for a modification. No one was required under the settlement agreement to seek a modification. They were simply offered that opportunity.
Is the argument that he didn't get notice of a denial, or is the argument that he didn't get notice of the possibility?
I don't see how he can argue that he didn't get notice of the possibility. There's an affidavit in the record from the settlement administrator, Rust, saying it was sent U.S. mail to his address, was not returned. We know he got the settlement check because he cashed it. I shouldn't say he cashed it. He used it to pay for dinner, according to the record. He signed it over. So we know he got that. And he may say he doesn't remember getting it, but it went out and the court concluded mailing it U.S. mail and the internet publication and the USA Today were sufficient notice. And with that, I see my time is up unless there are other questions. We would ask that the case be reversed and remanded for further proceedings in accordance with the arguments I've made here today. Thank you very much.
Thank you, Mr. Patterson. Mr. Collier.
Chief Justice, Justices, I want to respond briefly to the issues which have been raised by Mr. Patterson. First, Mr. Patterson and Wells Fargo throughout the case, in arguing that they are entitled to present extrinsic evidence to support their version of the foreclosure sale, wholly ignores an discovery order entered in the trial court by Judge Kerman after Wells Fargo had already violated its discovery order requirements. And that order said specifically, Wells Fargo shall produce all evidence as to the defaulting bidders, the manner in which that was done, and the accomplishment of the foreclosure sale. And that order means that the trial court could properly conclude, after 2 summary judgment hearings and 5 discovery-related arguments, that Wells Fargo was going to be limited at trial to what it had produced. And Wells Fargo here today said, well, these other bidders didn't want to get involved. Well, what Wells Fargo didn't say today was what it said at oral argument, which is its agents were the ones that contacted these bidders. Its own employee, its agents or employees were the ones who contacted these bidders. And those witnesses had personal knowledge and could have submitted an affidavit were it true. And the trial court judge to Wells Fargo counsel at that time said, how do you know that? And Wells Fargo said to the trial court judge, I know that because I called the foreclosure lawyer and he told me. And the trial court judge said, where's the affidavit? And Wells Fargo said, we don't have an affidavit. They never made an affidavit concerning those contacts. The trial court had told them in a discovery hearing that any information in the possession of your agents, employees, or attorneys is available to you, and you shall produce it pursuant to this discovery order. And they didn't bother. They simply ignored it. And now they come in front of the appeals court and say, we should be given a trial at which we could present the evidence that we did not get, despite the trial court's order for the summary judgment hearing. And not just once, Your Honor, 4 different hearings, the housing court said to Wells Fargo, are you satisfied with your discovery responses? And every single time, Wells Fargo said yes. Well, they're bound to that.
What would you say, though, to Mr. Patterson's argument that your objection to their use of an affidavit, which is been described as not based on firsthand knowledge, cannot similarly be used by you in support of your position in the case?
Evidence,
right?
Your Honor, evidence law is completely to the contrary. That is, a party on summary judgment must present summary judgment affidavits based on personal knowledge. An adverse party can use any statement by the adverse party. It used to be called the statement against interest rule. Now it's just a party admission rule, which means—
And you did not move for summary judgment, correct?
No, Your Honor, that's not correct. I specifically cross-moved for summary judgment.
Okay.
Contrary to—
Where is that in the record? Do you know what pleading that is?
I believe it's the surreply. It's at volume 3, page 19.
Page what? I'm sorry, 19?
Page 19 of volume.
Thank you.
So I cross-moved on all of these issues, Your Honor. They knew this was all in play. In fact, the trial court judge at the summary judgment hearing, and I just asked the court to read that January hearing, because the trial court judge looked at this so-called business record and said, I don't know anything about the reliability of this record. Why isn't there an affidavit? The trial court judge looked at the foreclosure affidavit and the interrogatory answers and the so-called business record and said, you're telling me that some lawyer told you on the telephone that some employee told them that they had contacted the borrowers. I mean, the
bidders.
defaulting bidders. And in fact, literally the trial court judge said to Wells Fargo, how do I know they were even contacted about their opportunity to purchase the property on their bids? And Wells Fargo counsel said, because I'm telling you that, because a lawyer told me that someone had done so. And the judge said, who did it? Who made the contacts and who prepared the record? And Wells Fargo said, we don't know.
But for purposes of currivassimus, tell me how that establishes that they would have been unable to meet that burden at trial.
Because they're going to be limited to what they produced in discovery pursuant to the discovery order.
Had there been an order to that effect?
There was an explicit order requiring, after the first violation, requiring Wells Fargo to set forth in their answers all terms of sale, conditions of sale.
Aware of that. I'm just asking whether there had been an order that that imposed as a sanction the limitation of their opportunity, or threatened to impose that as a sanction, the limitation of their ability to present evidence at trial.
There wasn't a separate written order, Your Honor. If you look at the passages at which the trial court inquired of Wells Fargo as to the adequacy of their discovery, he explicitly said, I'm going to check that and enforce it, but there was no separate written order to that effect.
What is it meant to say and enforce it? Does it mean to exclude anything beyond that?
Your Honor, I think the fair reading of the trial court hearing on summary judgment, and if you look at it, it was explicit, because after all of this argument, Wells Fargo said, well, maybe I could go out and get an affidavit now, Your Honor. And the trial court judge said, we're done.
That's for purposes of the summary judgment hearing. The question of what sanctions to impose for a claim discovery violation is there's a very wide range in the discretion of the trial judge administering the case, and the kind of severe limitation that you're describing usually carries a warning in a prior motion to compel hearing before the party is precluded entirely from presenting any additional evidence at trial.
The court's discovery order was after two prior discovery hearings.
I'm aware of that, but what you're saying in the present posture of this case is that not only could the judge have done that, not only did the judge intend to do that, it's clear reading between the lines, but it's appropriate to treat it as having entered for purposes of currivassimus. And I think that's a rather extreme statement.
Your Honor, the court did not impose that as a sanction for a discovery violation. The court took counsel's word that all the evidence that was available to it had been produced.
What you just said is inconsistent with that, Mr. Collier, because he said I could go out and get an affidavit, and the court said, no, we're done. So it's not the case that there was a blanket admission that there was no information available beyond what had been produced.
Your Honor, it's Wells Fargo's submissions to the court until the point at which the trial judge said, you don't have evidence admissible to prove your case in chief. It was Wells Fargo's position all the way until then that all of the evidence available to it had been produced and that it had fully complied with the court's order. And it told the court that at least 3 times, that all of the evidence and literally at one point, Wells Fargo counsel said, I've produced all the evidence we have. If I haven't produced it, and it's a quote, it doesn't exist. And the court was entitled to rely upon Wells Fargo's representation that any evidence it hadn't produced did not exist so far as Wells Fargo was concerned. And that was whether that was a strategic choice or whether that was an honest response, The result is the same, Your Honor. Wells Fargo represented to the court that no other evidence existed. The court was entitled to enter summary judgment based upon Wells Fargo's representation to the judge in repeated hearings that Wells Fargo had produced everything that existed, and that if it hadn't been produced, it did not exist. That was what Wells Fargo put before the trial court judge, and the trial court judge accepted it, said, okay, if you've presented all the evidence.
Mr. Collier, I mean, I don't have the full context of the statements that you've just quoted, but in fact, the bidders themselves had direct knowledge of whether they had withdrawn, right?
True.
And we have identities of those bidders, right?
We do.
Okay, so the question whether those bidders would have been allowed to testify at trial, despite the failure to produce any information directly from the bidders, is sort of beside the point, isn't it?
I'm sorry, Your Honor. I'm not.
It wasn't a well-framed question. There has been no order barring Wells Fargo from presenting evidence from the bidders at trial. You've suggested that the judge was winding up to do just that, but that was not in place at the time of the summary judgment argument.
I agree that no separate order had been entered. I think it was clear that what Judge Kerman had done was say, you claim your agents contacted these bidders and they refused to perform. You produced no affidavit or anything else from your own employees despite my order. So I'm limiting you to what you say your evidence is.
For purposes
Their
of summary,
evidence is that there were bidders. So their evidence is that there were bidders and that those bidders fell through. Now, and they're still, without an order saying otherwise, they can still support that by bringing the bidders in. So the question at summary judgment isn't, let's try the case in front of the judge, but can you support what you've produced, which was what you've produced is that there were bidders and that these bidders, even though they were higher than Wells Fargo, dropped out.
Your Honor.
So if they exist, and if Wells Fargo is telling you that they exist, or telling the judge they exist, how is that grounds for summary judgment?
Because, Your Honor, the evidence Wells Fargo produced included no evidence that they were ever contacted or ever offered the opportunity to purchase the property. And
so perhaps they have not established the basis for summary judgment in their favor, but I still am having difficulty understanding the propriety of entering summary judgment against them.
Your Honor, the propriety of entering summary judgment against them depends upon the trial court having properly limited their evidence based on all these repeated discovery hearings and all these orders to the evidence they produced in discovery pursuant to Wells Fargo's representation to the trial court.
I think he can limit them for purposes of the summary judgment argument, but to say that to extrapolate from that they are precluded on the procedural posture of the case at that time from introducing that evidence at trial, it seems to me it's a step farther.
Your Honor, I believe that's exactly the threat, the danger, and the risk that Corvus Salis poses, which is when you get to the summary judgment stage and you claim you've produced all the evidence that supports your side of the case, which is what they did here. If the trial court looking at that evidence can legitimately conclude that you have no prospect of meeting your burden, the trial court can enter summary judgment against you. And that's what the summary judgment rule itself expressly says, is that when a party moves for summary judgment and they show up at the argument, if the record supports entry of summary judgment in favor of the adverse party, even without a motion, the trial court can enter that summary judgment in favor of the adverse party because you failed to demonstrate in the trial court that you are capable of proving your case in chief.
Thank you, Mr. Collier. Thank you both. The case is submitted, and we will move now to the next case on our list.
All right, we are back live.
Okay, the next case on our list for hearing is case number 2019 P316, Alan Smith versus Decision One Corporation. The rules in this virtual Zoom hearing are very much the same as they are in court. Each side of the V has 15 minutes to argue. If the appellant is going to be splitting their time, please let us know ahead of time how you'll be dividing your time. And there will be a digital timer that will appear where the appeals court seal currently displays on the screen. Otherwise, the rules of the road are the same. No rebuttal. We've read your briefs. We're familiar with the factual and procedural background. You may begin.
Thank you. Good morning, Chief Justice Green and Associate Justices of the panel.
Will you be dividing your time with Mr. Schmidt?
No, Your Honor. My colleague Trevin Schmidt is here for the experience, and we appreciate his ability to attend, but I will do the argument today.
All right, all right. I'm sorry. Brittany, why don't you go ahead and start it at 15 minutes and we'll, okay, good to go.
No worries. And may it please the court. I am Walter Foster, and together with my colleague Trevin Schmidt, we represent the appellant Decision One, or D1. The fundamental question presented in this case is whether an at-will employee who agreed to and was paid under 2 successive written commission plans can be paid for sales made years after the original superseded plan expired by its own terms and by the conduct of the parties. The answer to that question is no, and identical to the legal analytical framework set forth in the Bywall v. 710 case, as well as the Okerman cases, the decision below must be reversed. D1 fairly and expressly implemented 2 successive commission plans, each of which contained an effective date, a termination date, in which by operation of fundamental contract law superseded the prior year's plans. The court below simply ignored material contractual terms that the 2010 plan terminated, and instead held that it continued throughout all of 2011 and 12. As the legal conclusion below is based on this entire holding, it must be reversed. There are 3 plans at issue in this case: the 2010, the 12, and the 13 plans. Critical to this court's analysis is that Smith at all times was an at-will employee. The record shows, and Mr. Smith testified at trial, that from the onset of his employment, he received both a salary and a commission basis. His initial 2008 commission plan was in writing and applied not only for all of 2008, but all of 2009. That plan, which was never signed, had no termination date. However, effective on January 1 of 2010, the 2008 plan was superseded and replaced. When implemented, the new 2010 plan expressly stated that it was effective for 1 calendar year, was 7 pages long, and each salesperson's individual quotas were set forth in a separate accompanying document to the plan called a PSP, a personal sales plan quota. At no time,
parties established a pattern of allowing that to continue even past its stated expiration time.
Yes, Your Honor, they did. In fact, the termination date contained within the 4 corners of the plan was a calendar year, and it was set to expire and did expire in December of 2010. However, a new owner purchased the company and had to readjust for their new fiscal year beginning, ending in March, beginning on April 1st. So the 2010 plan was expired under its own terms in December of 2010, but continued for 3 more months by the conduct of the parties, all the way through March 31st of 2011, when the new fiscal year 2012 plan took place. And in fact, that pattern was followed and set expectations throughout the entire conduct of the parties in terms of the successive plans. At no time did the 2010 plan, or during the pendency of this case, did Mr. Smith contend that the 2010 sales plan did not supersede the prior 2008 plan. And in fact, both the 12 and the 13 plans were implemented in a similar fashion with similar provisions within them. There's a general provision within the section of the 2010 plan that put all sales personnel, these plans were—
When do you say the 2010 plan expired? You say expired in April?
Your Honor, it
expired in December, but by conduct of the parties, it continued till April.
That's correct, Your Honor.
Was a new plan then put in place in April?
Yes, Your Honor. That is the 2012 fiscal plan, began on April 1st of 2011 and went through for basically a year.
Prospective to 2012.
Correct. And the terminology changed. They actually called it the FY, or the fiscal year 2012 plan. But it is in effect, and the testimony below and is upheld by the court, is that as the conduct of the parties extended the original, what I'll call the 2010 plan, but then as effective as of April 1st of 2012, according to the terms of that plan itself, was the effective date of that plan. It went all the way through March 31st of 2012.
How do you respond to the conclusion of the trial judge that these modifications effectively deprived Mr. Smith of compensation for services that he had previously performed?
Yes, Your Honor. So our contention is that as a matter of case law, both the Bywald and Okerman cases showed that the conduct of the parties, as well as the specific provisions of those successive plans, the 2012 and 13 plan, applied. Really, Mr. Smith makes an argument that a fortune cash register type of, you've deprived somebody of compensation due under the 2010 plan by implementing new plans. But here, Decision 1 gave fair notice of each of the implementations of the new plans. Its past practice and conduct of the parties anticipated yearly renewals. There were provisions within each of these plans, the 2010, 12, and 13, that set an expectation that they would expire. D1 acted in good faith for the entirety of all of those plans to address questions about the amounts owed. So what is very clear, and what we've put forth in our briefs, is a very, if you will, intense colloquy. And this begins in September of 2011, when the new 2012 plan is in place, where questions are raised about what do the commissions do. There are literally monthly trailing reports that were provided to each of the salesperson, not just Mr. Smith. D1 provided monthly reports for the entire period of time. There was an intense colloquy about what those amounts were due. For instance, in the 2012 plan, it had, which was in place, we contend, and that the facts show, from April 1st of 2011 through March of 2012.
Notice of that plan given.
The notice was given, there was, the record shows that the conduct was that notice is given by email and discussion amongst the sales team. And for the 2012 plan, there was testimony from Mr. Scott Gall on the record below that that was followed by the then boss of Mr. Smith to the entire sales team. The first monthly trailing reports went out in, because of course there's a tail for each of these plans allows for the prior plans, any invoice work under the prior plan to be billed and then invoiced. So the first monthly trailing report in 2011 went out in around the June time period. And so all of the parties, and by September, there's questions about the July and August commission payments. And so there's full knowledge of all of the parties. I do want to point out at no time in any contemporaneous manner, because there are major, if you will, questions and issues raised about, well, is this case, is this subclient of IBM in the right category? That's evidenced through September, October, November, all the way through March of 2012, where the rates under the 2012 plan were in place. Mr. Smith at no time during his tenure at D1 raised an issue that he should have been paid under the rates under the prior plan. This was only a litigation theory that arose after the fact. There's no evidence whatsoever that during the time that Mr. Smith did not understand that the 2012 rates applied. And in fact, the parties took great
So
pains.
I'm still kind of confused on because the 2012 plan, you're saying that the invoices don't come in till later. So, but when, I guess I'm not clear, when were they notified that these changes would take effect?
In April of 2011, when the plan came in.
So in April of 2011, they get told, you're saying he gets told that the new plan will take effect and it will affect what invoices?
It would be invoices that are then invoices sent in April of that year. So the chronology would be as follows. You're informed generally about the new plan. It comes in, and invoicing that occurs as after April 1st of 2011. So they have 30, 60, 90 days.
The invoices that occur after April 11, do they apply to work that took place before April 11?
No, Your Honor. No, Your Honor. It's my understanding is that the invoicing was for work that occurred in the April timeframe, to make clear, and really very similar to, of course, this court's decision in the Bywald case, where a new plan came in. At issue in the Bywald case was there was a lower commission rate of 40% that would apply. And one issue in that matter was that for sales made, there was, and I think correctly so, and I feel is dispositive to this case, is that the court held that the purchase order issued is the vesting time. The exact same analytical framework applies here. IBM, the only, if you will, client at issue is an IBM that had a master contract, if you will. And that was entered into, I believe the time frame is back in 2010. And so these are sub-clients of IBM. And then in April of 2011, when the new plan comes into place, when that is invoiced, the plan in place for that fiscal year would apply. It's just like what happened in Bywald. And that is the colloquy literally for the next 8 to 9 months that culminates in a March 26th email of 2012, where there is a running tally of all the commissions from April of 2011 all the way through January of 2012 are presented to Mr. Smith. He and Mr. Scott Gall, on the record, basically in email and as testified to at trial, says, I consider that the adjustments that have been made, and there were a number that were, of course, made in Mr. Smith's favor. One of those was a reallocation of a particular client from a percentage rate that went to a higher rate, a new account. So he received more money. One of those amendments was that the IBM Canada territory was taken away. And a third amendment was a Hilton sub-account was allocated to him at a higher 1.75% commission rate. So these plans worked exactly as they were intended. There were issues about, well, how much commissions am I due? Is this categorized as the right account? And that conduct of the parties is dispositive to both mutual consent and the consideration.
Mr. Foster, the trial judge made a finding that the 2012 plan was not shown to Smith and he did not agree to it. You contend that that was clearly erroneous?
Yes, Your Honor. He makes a finding. He says it's not clear from the evidence whether the 2012 plan was ever completed or signed by the appropriate official at Decision 1.
Right, but then in the very next sentence, he says it was not shown to Mr. Smith and he did not agree to it.
Yes, and Your Honor, we say that that is clearly erroneous on the record below. And what we point to is clear evidence is on, it's an email dated September, I don't have the exact date, but it's September of 2011, where Mr. Smith sends to Scott Gall a question about the inquiry under the 2012 plan, attaching a copy of the plan saying, this is what I got. All of the monthly trailing reports show those percentage rates under the new 2012 plan. For the next several months, all of the information is all about the 2012 plan. He had clear evidence and knowledge, and the record is replete with that knowledge, that of not only the plan itself, but its terms. And the 2012 plan didn't need to be signed. There's no signature page to the 12 plan. It's similar to the 2008 plan. It was promulgated and didn't need to be signed.
Okay, I want to ask you about one other finding that the trial judge made.
Yes, Your Honor.
And that goes to the 2013 plan.
Yes.
The trial judge concluded that Smith signed that under duress, and did so in exchange in part for an agreement that he could receive a draw against future commissions. But that once he signed the plan, D1 refused his request for a draw against anticipated commissions.
Yes, Your Honor. And as I read the court's decision, it's part 3 of his legal conclusions, is that Smith was in a reluctant agreement to amend the contract by signing the 13 plan was not supported by consideration. So, of course, what happened in the 2013, when that plan came in, there was a change in financial circumstances and a focus on new business. So his salary was increased by $25,000, so 25% increase. So the consideration was afforded there. In terms of the loan against the plan, a draw, if you will, in advance, that took place under the 2012 timeframe, where the allocations had already been made and Mr. Smith had accepted that. There was no argument here at the court that some sort of kind of fortune cash register claim came in about the 2013 plan. It was not intended to deprive Mr. Smith of any commissions whatsoever and was related to a business need. I see that my time has expired, and I'm happy to address any further questions that the court may have, and wanted to thank the court and the court staff for allowing us to do these live arguments by Zoom. It's very helpful.
Well, thank you. And I was remiss at the introduction of this hearing. I've done it at the other hearings, but certainly we all owe a debt of gratitude to our extraordinary clerk, Joe Stanton, and his team for putting this together so quickly. It really has allowed us to do business. And I also want to extend my appreciation to all of you for your cooperation with the rescheduling of these hearings necessitated by an unintended medical emergency on the 4th of May. But thank you.
Thank you, Your Honor. Thank you, Chief Justice.
Mr. Trundy.
Thank you, Chief Justice and Justices of the Appeals Court. I will defer to our brief on the discussion of these plans in detail. We did address the evidence. There was not a concerted effort in the appellant's brief to establish that there was not a basis in the evidence for the judge's findings. So we were a little perplexed by that. There's no specific claim of clearly erroneous findings. However, we did go through and we did show that in the course of trial, we learned new things, of course, whenever a case is tried. And we did learn in trial a couple of important things, one of which is that although the position of the defendant at the outset of trial was that the 2010 plan terminated at the end of the calendar year, they had in fact continued to live by it. It was not done by agreement. There was no discussion with Mr. Smith about how he would be paid commissions. The 2012 plan, in some various fashion, was enacted on the employer side without knowledge of the employees, the very salespeople. And this was extensively discussed and elucidated through the evidence. The 2013 plan was admittedly by Mr. Gall an attempt to strip this plaintiff of earned commissions. The commissions we sought in this case were all generated through IBM and all had start dates, contract dates that were within 2010 and 2012. They all predated the 2013 plan. In addition, the 13 plan was like the 12 plan. First of all, the 12 plan was never ever produced in any complete fashion. We don't actually know what it was. And but the 13 plan was produced, and it was produced retroactively, or after the fact, retroactive after they had already started stripping Mr. Smith of his commissions. And so there is very specific communications in this record indicating that if Smith did not sign that plan, he would be terminated. Yes.
You brought up something about the stripping him of commissions he earned on the 213 plan. Where in the record are the documents that would suggest what that calculation should be? And wasn't damages something that Mr. Smith would have to establish?
Yes, well, we did. And as Mr. Foster mentioned, there's a thing called a trailing report. This is the monthly report that shows as to each account of these various salespeople at D1 that what was billed for the work that they had contracted or sold. And all of those reports month to month are in the record as to the IBM accounts. And those are what we used. We took those reports and based on the explanation as to how you would apply the 2010 plan, which was provided by the D1 witness, Mr. Gall, who was the guy who also was doing the actual calculations. We calculated using his very conservative, the most conservative view of that 2010 plan, which is the only plan in this record that Mr. Smith ever actually agreed to, and was the plan in effect when he went out and did the heavy lifting for a long period of time to get these contracts from IBM. And so
he was an at-will employee, right?
He was indeed, yes.
Wasn't it open to the employer to terminate his employment at any time without cause?
Yes, but as we know, I mean, there was a claim in this case which we waived as to termination and pursued only the commissions. But yes, they have a right to terminate, but they are also, as you know, that there is case law that suggests that you can't terminate somebody for the purpose of stripping them of commissions. You would still.
No, I understand that. Well, for the purpose of stripping them of commissions, if they are entitled to payment of commissions for services previously rendered, the termination of their employment would not cut off their entitlement to recover those amounts.
And this is what this case was always all about, because as the record showed, he spent 1.5 years of his time doing the spade work, the sales work, to land this extremely lucrative contract with IBM.
So it's your contention that because he produced that relationship, he was entitled to payment even beyond the time of his departure from the company.
No, we waived that part of the claim. The damages in this case go up to the last full month that he was actually employed, which I believe is August of 2012, the 2013 plan covering 12-13. So we did not press the issue as to the money that was on trailing reports past his termination, because that raises other issues as to who might have been maintaining accounts and so forth. We did, however, claim that what we did is we looked at each account as it was set up. So if you look at those trailing reports that are in the record, they will show like IBM Best Buy, that was set up at a certain month and year, and a cash stream follows from that. We say that each of those initiated subcontracts were a sale, and that the only thing we were waiting for is the billing and assessment as to what they were going to collect under that.
How do you respond to Mr. Foster's comment about the raise in base salary?
Well, what they did is they said that they admit that they set up this last plan for the purpose of stripping him of commissions. That is in the record. That's an admission. They then say to him, what we're going to do.
Past commissions or future commissions?
Past commissions. Anything owed from the IBM account was intended to be stripped from Smith by the 2013 plan. In other words, all of that work that he had done from IBM, forget about it. We're going to take that away from you, and you can start from scratch. And they provided that.
Is that because you're saying the contract with IBM hadn't been solidified yet, and therefore, by the time it does get solidified, it would fall into the 2013?
No, those were for contracts those were for sales made.
How does the contract take? How did the contract take those commissions away?
Well, what it did is they had, before the 2013 contract was ever offered, they had stopped paying him under it. They just stopped paying all commissions for several months. Then they provided a 2013 plan retroactive to a month and a half, 2 cycles before.
Oh, because now we were saying that it wasn't going to be, you're not going to get commission for ongoing relationships, only new relationships.
Only you have to go out and sell brand new business, start another year
So
and a
you're
half.
saying that under the old plans, he was entitled to, because he had made the relationship with IBM, and that was lucrative, he should still be getting ongoing commissions for that as long as IBM continued with the company.
As to discrete contractual relationships, which appear in the trailing reports. So there are certain specific contracts to do specific kinds of backroom computing for Sears, Kmart, and Best Buy, and various other entities, and Spirit Airlines. And so each of those is their own contract. And what was admitted by Mr. Gall at trial was that the purpose of the 2013 plan was to strip him of those commissions. And it stripped him of commissions before he even saw
because they fell under IBM, and IBM was a prior contract, and now
he had made the sale. Yeah, he had made the sale. And so what they then did is said, well, we're going to give you a raise, but they fired him 6 weeks after they gave him the raise. So the $25,000 never materialized. And it leads us to this awkward position where we say that we're going to take away what you've earned, and in exchange, your consideration is we're going to let you to keep working for us to get more business in the future. And I think the judge has completely looked at this as both a failure of consideration and unfair way of doing business, because it was motivated by, admittedly, stripping him of commissions, and that they didn't honor the base term, which is to give you an advance, and then they fired him. And that he looked at that, all of which was taking place in a very short, compressed period of time, and a threat to terminate if he didn't sign it. So they threatened him.
You make a number of points in your brief about the failure of the defendant to file a motion for required finding, and they didn't file post-trial motions and the like. How does that affect this appeal, if at all?
Well, I don't think, I think our point was that really relates to this idea that there's a claim that we didn't properly calculate damages, and that the judge accepted our damage proposal in our post-trial documents.
Right.
There was never a calculation ever done under the 2010 plan, or any real explanation as to what D1 said they should have paid.
But you're not suggesting that they've waived that claim about the what they claim to be speculative damages?
No, I don't think they, I believe that is a de novo review in terms of the analysis that the judge applied. But I do think that the record is substantial in our favor. Of course, we're the employees, so we're at the mercy of what information we obtained. There is an interrogatory in the record, which you can see there are multiple attempts for us to ascertain from D1 in discovery, which made it into the trial record, which shows that at no time would D1 ever explain to us how they generated these commissions. And it was a running problem that essentially, if Mr. Smith complained, they would give him a big check. And none of it made any sense in term or rhyme or reason. So what we did is we took the best information that we had, which is the trailing reports. We applied that specifically to the analysis of the 2010 plan given to us by Scott Gall and the trial record. So the judge is looking at admissible evidence that was admitted by agreement, testimony of Mr. Gall, who is their witness. And when you apply those together, this is what, and we did the math, which was really running the numbers, and then the judge applied it. And I think it's a completely appropriate way to do it, given the totality of the evidence and the relationships between the parties here.
And you're requesting appellate fees and costs in connection with the appeal?
No, we are not requesting. No, I think we simply asked for cost of the appeal, although I don't think there are any from our side. I don't believe we asked. There's no attorney's fees claim that was ever brought in this case. Other than that, I would rest on the brief, and thank you so much.
Right. Thank you all. That concludes the argument in this case. The case is submitted. We will return to the waiting room, return you to the waiting room, or I guess end this call for you and bring in the next attorneys to the argument.
Alrighty, we are live streaming.
All right, that brings us to our next case, case number 2019 P231, John Doe number 24358 versus the Sex Offender Registry Board. I'm going to remind counsel that we are streaming live to YouTube for public access, but this case is impounded. I would ask that you refrain from reference to any names or any other impounded material that's not suitable for public airing. The rules for this virtual Zoom hearing are identical to those in the live in-person courtroom arguments. 15 minutes to a side. There is no rebuttal. We are familiar with the arguments that you've made in your briefs with the factual and procedural background. You needn't recite that. There will be a digital timer that will appear in the frame where the appeals court seal currently is. It does not have the green, yellow, and red lights, but it does turn to red when your time has expired. I want to thank, as I have at each of these other arguments, the extraordinary work of our dedicated clerk, Joe Stanton, and his team to have made it possible for us to continue operations on as nearly a seamless basis as we have. And I want to thank you for your courtesy and accommodation of the need to reschedule this argument after a medical emergency, non-COVID related, on May 4th. So with that, Mr. Coase.
Thank you, Your Honors. May it please the court, Matthew Coase on behalf of Mr. Doe. SORB's regulations require that the hearing examiner assess the reliability of the evidence and make specific findings of fact on all relevant disputed factual matters. One of the disputed factual matters in this case was whether Doe actually committed his sex offenses, particularly the 2013 sex offense. SORB used the evidence that SORB used to prosecute its case against Doe lacked general plausibility, consistency, detail, and corroboration. The hearing examiner's decision shows that she made up her mind that Doe committed these offenses and then cherry-picked snippets of evidence that allowed her to reach her desired result. Had she done a deep dive into the evidence, as she was required to do, she was likely to reach a different conclusion.
What is the standard of our review?
I believe we're at a de novo review in terms of reviewing the record. There is discretion given to the agency, but I think with respect to the record, the court really stands in the same position. You're suggesting that we conduct de novo review of the evidence of an administrative review? Well, the agency is required to get deference, but when we're looking at whether or not there is clearly erroneous factual findings, which I think this case suggests, then that
clearly erroneous is not de novo.
Well, I apologize then, Your Honor.
But ordinarily, we don't even use the clearly erroneous standard in our review of an administrative proceeding. Isn't our normal review for substantial evidence?
Well, that's the argument that I made with respect to the evidence that was presented, that it did not rise to the level of substantial evidence.
I understand that, but just to put foundational rules of the road out there, we do not conduct a de novo review of the evidence. We are conducting we don't even look to see whether the factual findings were clearly erroneous. We look to see whether the agency decision is supported by substantial evidence.
Thank you, Your Honor. And I believe that I've argued in the brief that the hearing examiner's findings were not supported by substantial evidence.
I understand that, but I want to just want to make sure that we get that baseline set, because to the extent that you're suggesting that that she overlooked some pieces of evidence or that she did not give due weight to others, that's a heavy lift under the substantial evidence standard.
That's correct, Your Honor. And I think this is one of the rare cases in which that argument can be made in one. There's two pieces of evidence that she relied pretty heavily on. The first piece of evidence is the SANE interview from victim 2. She didn't have the SANE interview in front of her. She had kind of secondhand accounts, observations of what occurred during the SANE interview. There's a DCF worker that wrote up a report, and then there was the police officer that wrote up a report. So they're summarizing their observations of what occurred. One of the main things that stands out about the SANE interview, what the victim said during that interview, was that the grandmother, the maternal grandmother, and on another occasion, her own mother, were present while the sexual assault allegedly occurred. That argument is in all of the accounts of the SANE interview. It appears on pages 14, 26, and 72 of the record. But that pretty significant fact was left out of the hearing examiner's decision altogether. And I think it goes to plausibility. When you look in the Doe 10304 case, it talks about whether or not the victim's allegations are generally plausible. Now, again, having the maternal grandmother present while these sexual assaults are occurring, and having the mother present while these sexual assaults occurred, and having them not really do anything about it, seems to really kind of contradict common sense and the general plausibility. One of the other things that the hearing examiner relies pretty heavily upon is the grandmother's statements during the grand jury.
Is there a difference between being present and observing?
Well, I think she said that the victim said they asked her, what did the grandmother do, or what did your mothers do? And she said they told them, don't do it again or you get kicked out of the house, is what the victim said. So clearly the victim thought that they were watching. And if we're going to kind of put credence into her statements, then her belief, and the hearing examiner credited other things that she said about the way it felt and how he dragged her to the side of the bed. So we can't just take the statements that we think are helpful and disregard the rest. I would also—
what you're suggesting is that as a matter of law, that it was error for the hearing examiner to credit those statements by the victim.
No, it was not error of law, but if you're going to credit some statements, you have to credit all of the statements.
Where is that? What's your best case for that? That's a relatively novel proposition in my experience.
Well, I would say that the Doe 10304 case or the Doe 523391 case, and again, it talks about the corroboration of the evidence, the general plausibility of the evidence, whether or not that person has a motive to lie. So we're looking at what this victim's statements is in the greater realm. And it's also important to—
Yes, but neither of those cases stands for the proposition that you just pressed, that that you have to, it's an all or nothing proposition for the hearing examiner to either credit or disregard the statement of the victim.
No, not specifically, but there are plenty of cases in the 30A realm that says that the reviewing court needs to look at the entire record, not simply the portions that the hearing examiner used to support their position. I would also point out that the hearing examiner said that Doe's offending conduct was discrete. She says that on page 14 of her decision. So I'm suggesting that she wasn't looking at all of the evidence to make up her mind. I'm suggesting that she made up her mind and then took the evidence that helped her get to the decision that she wanted to get. Had she actually looked at those statements, it appears in every one of the sane interview summaries that there was at least the grandmother present, and yet she decided to say that the offending conduct was discreet. I also want to talk about the grand jury testimony as well. The way that the hearing examiner teased it up in her decision, and certainly my brother characterizes it in his brief as a contemporaneous statement, that, you know, she woke up in the middle of the night and someone touched her pee-pee. But that's not what the actual grand jury testimony says. And I regrettably, I didn't make a bigger point of this in my brief, but what she said, what the grandmother says when testifying before the grand jury was that that the victim told her mother that someone had touched her pee-pee, and it was either the grandmother or the grandfather, Doe. So now the hearing examiner is corroborating these statements using third-level hearsay from the victim to her mother to her grandmother. And when you go on to read that statement in the grand jury testimony, she's not talking about the event that kind of precipitated the DCF involvement. She's talking about an event that occurred 6 months prior. She goes on to, as a matter of fact, as she's telling this, the prosecutor stops her and says, wait a second, what are you talking about here? Are you talking about this event or are you talking about a previous event? And she says, this was a previous event that occurred about 6 months ago, and we took the girl to the pediatrician's office and got her checked out. So the way that the hearing examiner phrased it makes it seem like this girl, you know, woke up the next morning, told her grandmother that someone had touched her pee-pee. But that's not what happened. The girl told her mother, and the mother relayed the information to the grandmother. And it was for, you know, a different event, not the event that.
Can I ask you about the DCF records, Mr. Coase? The board makes the argument that you waived that argument below, and I've read your reply brief, but could you address the waiver question and then the ability for the hearing officer to consider the DCF records?
Okay, thank you, Your Honor. With respect to the waiver issue, this was raised at both of the SORB hearings, the first SORB hearing, the remand SORB hearing, and it was raised in front of Judge Wilkins when it went up to the Superior Court the first time around. And Judge Wilkins, in the 30A, basically made a ruling saying that it was appropriate for the hearing examiner to consider the DCF records. So my position would be that was the law of the case. Arguing it in the Superior Court the second time around would have been futile, where the Superior Court had already ruled on it that it could be allowed. I think if we were to go directly to appeal from the first Superior Court case, we could have raised it in the appeals court for the first instance if we were allowed, or if we went in that direction. But what happened here is we won on a different issue and the case went back, and now the board's trying to say that we waived the issue because we didn't raise it the second time around. So in essence, Mr. Doe would be penalized if he couldn't raise it on appeal. You know, essentially he would get penalized for winning on a different issue. And then with respect to the substance of the matter,
it's one thing to say that the court is not obliged to reconsider an issue, but another to say that that if you want to preserve the claim for subsequent review, you have to renew the request and then put it to the court to decline to reconsider the prior ruling.
Well, I would disagree with that, Your Honor, in the sense that we're in one case here. You know, it went before the board, it went to the Superior Court, it went back to the board, it was raised by the board, and so over the course of the entire case, it's been raised numerous times, and you know, decided by the Superior Court. So I don't think And I think that the cases that the board cites for this proposition says that it's raised in the appeals court for the first time, which is it's a subtle distinction, but as I just mentioned, this has been raised throughout the course of the case.
Except in the proceeding that produced the decision from which you now appeal.
Well, I think that we're appealing the previous Superior Court decision and the current Superior Court decision, because there's been rulings of law in both of them, and it impacted the way that the second hearing took place. And now the appeals court is reviewing the entire case as a whole.
Wait, you think Wilkins and Raschudi's decisions are before us?
I do, Your Honor. I do. I focus particularly on the issue with respect to the hearing examiner's findings with respect to particularly the 2013 offense. And I don't think that anybody has suggested that that was raised improperly. But again, I think once the Superior Court makes a ruling, it becomes the law of the case, and we're in one case. Although it went to the Superior Court twice, it's still the same case. I see I'm getting low on time, but Your Honor did ask a question about the substantive on the DCF reports. I think the statute at issue kind of says that the DCF reports are confidential, and they set in place a mechanism by which these records can be obtained. And I don't see that SORB went through the process of obtaining these correctly and getting permission to use them in a SORB matter. And I know that the SORB relies upon Chapter 6, 178K. There's a provision that talks about file sharing, but I don't think that that particular statute on its face says that all confidentiality issues that are raised in the 51E statute are waived because SORB wants to use them at a SORB hearing.
Thank you, Mr. Coase.
Thank you.
Mr. Chenell. Mr. Chenell, we're not hearing you. No.
No.
Not. We have no audio, Mr. Chenell. Try again. Mr. Chenell, can you hear me? Can you hear me, Mr. Chenell? No. Brittany, why don't we see if we can get Mr. Chenell back to the waiting room and back in. Welcome back, Mr. Chenell. Can you hear me? No. Okay. Let's suspend this hearing on the live stream briefly, and Brittany, live then.
Okay, David Shania for the board. I like I said, I didn't hear the last 5 minutes of Mr. Coe's argument, but I didn't want to interrupt because he seemed to be doing so well. So I figured I'd better not say anything until it was my turn. The issue as to the statements, it really comes down to whether or not that evidence represents substantial evidence. And the hearing examiner has a lot of discretion in determining what evidence to consider. And what we're looking at is whether that hearing examiner abused that discretion. And in this case, you look to determine whether hearsay is reliable, is whether or not that, first of all, is it detailed? Is it?
Well, can I just interrupt you, because I think because you didn't hear the last 5 minutes, what you missed was the argument that he made that it was improper to use it, not only because of its reliability, but because SORB did not access it properly and did not use the proper statutory means, and therefore there was no waiver of the privacy under, you know, the 51E privacy, because SORB did not get it, use some kind of share file to get it, and not the proper means of accessing it.
Okay, first of all, the DCF records under 178K are part of records that are shared with the board. They don't have to go through any process whatsoever. They're required actually to share their records with the board. It's part of the whole EOPS's situation where they can, different agencies can, for public safety issues, interrelate with each other as to information. So the DCF, we didn't have to follow the same statutory requirements of going to court and getting a court order and having the court look through the records first. We have a right, and again, part of the issue here too is that our hearings are impounded, so it's not like that information is going to be made public. So we have a right to look at those records. More importantly, if you look at down below, that issue was waived. It wasn't waived at the, it wasn't argued at the Superior Court. So
that was one of the questions that came up, unfortunately, I think during that last 5 minutes. I asked Mr. Coase if he thought both Judge Wilson and, or Wilkins, excuse me, and Judge Raschudi's decisions were before us, and he said yes. Do you agree with that?
Before you?
That both Superior Court decisions are before us.
Correct.
And so his argument is that he raised it in before Judge Wilkins, and that
Right.
preserved the claim of evidentiary error for our review.
No, actually, it was raised and it went back to hearing with the board. It wasn't raised at the board hearing, and then it went back to the Superior Court, and it wasn't raised at that time.
Yes, but his argument is
I bet both decisions are in front of you in the sense that you both can see both decisions, but he should have raised it at the hearing the second time, and he should have raised it again in the Superior Court. So the board's position is he waived it.
yeah, and his contention is that that once the Superior Court, the first Superior Court judge ruled on it, it became the law of the case. Okay, we've lost Mr. Chennail's audio again. Let's again suspend. Brittany, look at the time clock, and we will have him go out and back in again. Okay.
All right.
I guess going back to the statements that were used by the hearing examiner, I think I did a good job in the brief outlining why the board's position is that not only does it represent substantial evidence, you know, one of the things, if you look at this, what the plaintiff is asking is to have it both ways. He's saying he didn't do the crime, it didn't happen, but at the same time, he pled guilty to it. Now, I've practiced criminal law for almost 30 years, and my memory of every Superior Court time an individual pled guilty, the judge asked him, are you pleading guilty because you are guilty and for no other reason? He had to have said yes. So either he lied to the court or he's lying when he says he didn't commit this offense. So I think that has to be factored in, because the hearing examiner, although can't rely solely on the guilty verdict or a guilty plea, it is something that is indicative.
We've lost you. Okay. Let's again suspend.
I would leave.
Okay, we're back live. Brittany, put the timer on, and we'll do our best to approximate the time. Okay, Mr. Chennail, I'm sorry. These technical difficulties do occur occasionally, and we'll soldier on.
Well, there's nothing we can do about it except for just soldiering on. So I don't really worry about that much of these things.
Okay.
Again, I think I left off, I was talking about the credibility or the corroboration of the statements. And again, I think that the hearing examiner had the discretionary authority to consider what evidence. And right now the issue is whether or not the hearing examiner abused their discretion. I think 523391, which discusses hearsay evidence, specifically says that we have to look to see whether or not this was evidence that that a person should be able to rely on. And the board's position, of course, is that it was reliable and the hearing examiner didn't err in considering it to be substantial evidence and applying the factors to that evidence, which is basically the main part of my brief and the argument that we have.
Can I get back to the waiver issue? Why isn't it true that once one superior court judge made a ruling on it, that when it went back on remand, that was the law of the case, and therefore there was no idea of bringing it back up again?
Well, the whole idea of waiver is to give, if that was raised in the Superior Court the first time, the whole idea of waiver is that you allow the underlying hearing and then the underlying court to address that issue specifically. Again, when it was remanded to the board, it should have been raised again at that point, so the board can consider and at least give their ruling on the matter. And then again, it wasn't taken up a second time in the Superior Court. Now, that's the board's position on the matter. If this court has a different position, that's within your prerogative, and that's why you're there and we're out here. But in the ether land. But the reality is, it wasn't raised to the board when it had an opportunity to, and then wasn't subsequently raised again in the Superior Court. And the board feels that represents waiver under the circumstances. But regardless, it's not even an issue in the sense that the board's position is 178K Section 4 grants us full authority to have those records as a part of an interagency sharing program that is held by the executive branch. And if there's no other questions, I'd be more than happy to rest on my brief.
Seeing none, thank you. And again, I apologize for the technical difficulties. Thank you both.
No need to apologize. Like I said, these things happen all the time. Thank you.
Thank you.
Thank you, Your Honor.
Okay.
Okay, we are live.
Okay. This brings us to the last two cases on our list for argument this morning. The more observant of those spectators will notice that we have a panel change. Justice Wolohojian is sitting instead of Justice Maldonado for this case. These last two cases are case number 2019 P1483, Miguel Espinal and another versus Ace American Insurance Company and another, and case number 2019 P1484, Martin Herrera versus Ace American Insurance Company and another. Attorney Martin will be arguing on behalf of for Great Divide Insurance for both parties. Each side will have 15 minutes to argue. There is no rebuttal. Mr. Harris.
Thank you, Your Honor. Good morning, and if it please the court, my name is Garrett Harris, and I'm here today representing Ace American Insurance Company in what Your Honors are aware is two joined workers' compensation claims by Miguel Herrera and Miguel Espinal and Martin Herrera. There was no issue at the Department of Industrial Accidents about the injuries and that they were in the course of Mr. Espinal and Mr. Herrera's employment with cruise abatement. They were both unfortunately injured in the same accident. What was really an issue in the case and what brings us here today was the issue of the validity of Ace American's cancellation of cruise abatement, the employer in the case, of their workers' compensation insurance policy. As the court maybe is probably familiar with, the way workers' compensation works is if the employer does not have an insurance or valid insurance, and there's a general contractor above them, the general contractor's insurance would apply, which is what brought Great Divide into the case and their insured employer. Your Honor, there are two essential issues in the case, which I think have been raised in the briefing, and that is the position that the Department of Industrial Accidents has taken that in the case of the cancellation of what's called an assigned risk workers' compensation policy, which was the cruise abatement policy in this case, issued in accordance with Chapter 152, Section 65A, that the insurer needs to prove that the insured received the cancellation notice. There's no requirement in the statute for that, and it's our position that that is a incorrect position legally that the Department of Industrial Accidents has taken. The second issue in the case is, if that's the case, if there's an obligation on the insurer to prove receipt, we believe that we did prove receipt in this case based upon the evidence and based upon the hearing decision of the hearing officer, which did not take into account the what we call the mailbox rule, where an item that is properly mailed through the U.S. mail system, if it's shown that it was properly mailed, which was in this case, and seemed to be accepted by the judge who decided the case, that is prima facie evidence of receipt of that item.
May I ask you a question on that front?
Yes.
And I'm sorry to interrupt you. It's short of, waiving. I don't know how else to jump in, so I'm sorry about that. I may have misunderstood some of the facts in the record, so hopefully you'll be able to correct me. But as I understand it, the subcontractor insured paid a bill on August 16th, 2016.
Yes, Your Honor.
And your client accepted that payment?
Because that was what was owed for the policy. The way these policies work, and I think I laid this down in the brief, is that they are subject to an audit. So after the policy expires, whether on its usual expiration date or upon cancellation, the carrier has the right to go in and audit the payroll and the exposure of the company, and then they calculate the premium. And what happened here was, after the cancellation occurred, an auditor eventually went in to audit cruise abatements records and found that they owed additional money beyond what they had already paid. So that was payment not for continuing the policy or for reinstating it or avoiding the cancellation. That was paying what they owed for the period of time that the policy was in effect.
But okay, so that was paying a premium for the period the policy was in effect before which date? When you say in effect, what?
Up until I'm sorry, Your Honor.
What's the end date?
May 8th of 2017, I believe was the year, which was the date that the policy was canceled.
Okay, so May 8th. So you're saying that the payment in August was a payment to cover a period that expired before this accident occurred?
Before the accident and the period up until the date that the policy was canceled.
All right. So, so in your view, does the fact that the insured responded to, there's a sequence of events where on previous occasions when the insured is told that its policy is being canceled, it then goes and takes steps to get back into the pool and get a new policy. And there are also facts such as this one that show that the insured is responding to some communications from your client, including a bill. Do you not think that the judge could infer from those facts that there had not been actual receipt of the notice of cancellation, since this insured does seem to respond to some of the mailings that it gets?
I don't think they could, Your Honor, because this was basically a premium that was billed as a cancellation audit. And I believe the documents in the file show that the period of time for which the premium was being billed was just for the canceled period. And one thing you just alluded to in the first part of that was the issue of going back into the pool. One of the requirements to go back into the pool is you have to square up your arrangement with the prior policy. You need to pay all the outstanding premium. And there was some evidence in the case, which I mentioned in the my brief notes in the transcript, where the producer, the agent that had been working with Cruise Abatement, was dealing with calls from one of Cruise Abatement's people about getting them a new policy. And so that I don't think there really be any basis to infer anything one way or the other about the insured's receipt of the cancellation based upon the fact that they were paying a premium bill for a canceled policy. And from all the circumstances, I think the more clear inference is that they were doing so they could go back to the pool and get a new policy, which in fact they never did. They never applied and appeared to have gone out of business entirely.
Okay, but at a minimum, you would agree that there's no direct evidence of receipt of your notice of cancellation.
I would agree, yes, Your Honor. There was no return receipt, and there's no testimony by somebody saying, yes, I received this.
Right.
But
Okay, but you're saying that either it's just the presumption caused by the mailbox rule, or perhaps in the alternative that circumstantial evidence would lead to a reasonable conclusion that they had received notice.
Yes, Your Honor, with an emphasis on the former, where the findings by the administrative judge and all the evidence, testimony and so on, made it very clear that the notice was mailed. This isn't one of those cases where it was mailed to the wrong address, or notice wasn't given to the rating bureau, or there was some other technical defect in the mailing. The evidence was unequivocal that it was mailed, and that evidence was never contradicted. So
Mr. Harris,
argument would be.
Mr. Harris, we know that that this is not a position the board has taken simply for these two cases. This apparently is a position of long standing. It was cited in a footnote in a case written by Judge Cohen a number of years ago, without comment one way or the other. But we do have a principle of deferring to an agency's reasonable interpretation of the statutes it's charged with administering. Why doesn't that allow the board to make that take that position?
For a starting point, Your Honor, we don't think, given the statutory language, that it's reasonable. And Section 65B itself says that the insurer may cancel or otherwise terminate such policy in the manner provided in this chapter. And the manner provided in the chapter is giving notice to, it used to be to the department directly, now it's to the rating bureau, and giving notice to the insured. And in the Armstrong and Cummings decisions, which are the decisions that have fleshed out some of these issues to some degree. That was the only thing the appeals court articulated, was that you have to give notice to those two entities. And the one thing that adds another layer of what the obligation is in this case, which has been also recognized by the appeals court, is Chapter 175, Section 187C, which is an insurance statute, but basically provides the method for cancellation of any insurance policy subject to cancellation in the Commonwealth. And so those are the only things that set out the obligation for getting a cancellation done. And we believe that to extend beyond that, particularly where when the legislature intends that there be actual certified mailing as opposed to a certificate of mailing with a return receipt, they've articulated that in the statutes. So our position is that it's not reasonable for the department to take a position that's not consistent with the statutory language itself.
Okay, so but how does that work then? If we accept the fact that that notice is permissible without return receipt, and that the 10 days runs from the date of receipt, how do we determine when the 10 days expire?
Well, I think one thing that could be applicable is what the court rules are, that you basically add 3 days to the notice to account for the receipt period. And that there could be a question in a case where, say, an insurer has filed an objection under 65B, and there could be a question. I've handled cases like that. There's a question as to when they received it, and that's when you could look at circumstantial evidence, you could look at credibility, you could look at the type of mailing that was done, and you could make that determination based upon the evidence. But
So how do you distinguish? Your brother's brief suggests at page 15 that the mailbox rule doesn't apply to the assigned risk pool policies. And I'm still having trouble understanding why you say that's wrong as a matter of law.
Well, with respect to the mailbox rule, the mailbox rule is a general rule of law for more than 100 years, I believe, in the Commonwealth with respect to mailings. And none of the statutes and even the Department of Industrial Accidents, and I cite this in my brief, has expressly recognized the application of the mailbox rule, particularly in the form of Section 187C. Then the DIA has used the expression mailbox rule.
So he cites Pillman's case in support of his argument that the mailbox rule doesn't apply. So what do you say to that?
I don't think Pillman's case says that. Pillman's case was dealing with what's called a voluntary policy, a non-assigned risk policy, and it just looked at the standards of mailing and so on in an ordinary non-assigned risk policy cancellation.
So that's the distinction, the voluntariness?
Yes, Your Honor.
Okay.
And to get, if you can need some context, what the voluntary means is that no carrier is willing to voluntarily issue a policy, and when you are turned down by 2 carriers, you're allowed to go into the assigned risk pool. So I think that all the case law, when you read it all together, certainly with respect to the mailbox rule, doesn't say at all that the mailbox rule, that there's somehow an exception for assigned risk workers' compensation policies to the mailbox rule. There's nothing in the statute which says that, and there's certainly nothing in the case law that says that. Certainly the DIA.
If we were to agree with you, is there then a question? I mean, the mailbox rule doesn't prove receipt, right? It establishes a presumption.
It is prima facie evidence that it was received.
Right, but that can be disproved, right? If the other side says, I did not actually receive it, and that's credited.
Could be, Your Honor.
Right.
But prima facie evidence remains evidence in the case, and it could still be a basis for a determination along the lines of the prima facie evidence, even with contrary evidence. It's greater than a presumption.
But if we were to agree with you on the question of law, wouldn't it need to be remanded on the question of fact, which is, whether taking that prima facie evidence, there was receipt?
I don't believe it needs to be, Your Honor, because when you read the administrative judge's decision, she made all the findings that we mailed the notice, first class mail, got a certificate of mailing. The findings of fact that support both the mailing generally and the compliance with Section 187C are on the record. I think what happened was that the judge made all those findings, and then even though we had raised it early on in the case and raised it in closing memoranda, she just simply did not apply the mailbox rule.
Was the issue of actual receipt joined down below? Was there any evidence, direct evidence, one way or the other, on whether the insured actually received the notice?
As I indicated earlier, we agree there's no signed return receipt, and there was no testimony from anybody from the insured, and it's in the record. We had tried to bring in the owner of the company, and we were just not able to get it. We weren't able to get service on her, and it appears that our understanding was that she was homeless. I don't believe any other party in the case tried to bring them into the case. So at the end of the day, when the case was done, the evidence was we'd complied with the mailing, sent it to the right address, right postage, certificate of mailing, et cetera, and there's nothing to
no contradictory evidence.
None whatsoever.
All right. Thank you. Mr. Martin.
Thank you, Your Honors. May it please the court, my name is Robert Martin, and I represent Great Divide Insurance Company, care of Berkeley Environmental, which was the insurer of the general contractor in this case, Moran Environmental Recovery. What my brother and Ace are asking you to do here today is to reverse decades of case law from both this court and the reviewing board on the termination requirement under Section 65B.
What is the case law from this court?
Well, Pillman's case specifically, there's 4 cases that from the appeals court that address Section 65B's receipt requirement. Those cases are Armstrong in 1999, Cummings in 2001, Pillman's in 2007, and Visco in 2012. Armstrong actually dealt with a prior version of Section 65B, which required department approval of the termination. That's no longer part of the statute. But so that Armstrong is really not definitive on this case in the current version of Section 65B. Cummings' case, which was actually handled by another attorney in my office, that dealt with the current version of Section 65B, and the appeals court found that the insurer there failed to effectuate termination of the policy, an assigned risk policy, because it could not prove receipt of the notice by the rating bureau. Slightly different because it was a question of whether the rating bureau received it, and here it's a question of whether the employer received it. But the comparison is the same.
In that case, was there evidence that the insurer sent the notice to the ratings bureau?
There was, from the insurer, they testified that they sent it. The rating bureau's file was subpoenaed in that case, and there was no notice of cancellation in the file, so they could not prove receipt. They also did not send the notice certified with a return receipt request, the green card that is common on many mailings.
So that case maybe turns on a question of fact rather than the question of law that you're arguing now.
Yes, Your Honor. Well, the question of law in this case is whether Section 65B requires proof of receipt. And I would point, Your Honors, to
actual receipt.
Actual receipt. I would point, Your Honors, to the plain and unambiguous language of the statute. And despite what my brother argues, I argue the exact opposite. The plain and unambiguous language of 65B does require actual proof of receipt by both the rating bureau and the insured, the employer.
Wait, actual proof or proof of actual receipt?
Proof of actual receipt.
Okay.
The statute 65B states that the insurer, quote, shall give notice in writing to the rating bureau and to the insured. Now, the words shall give in their plain and ordinary meaning, shall is mandatory, means must, and give, according to Merriam-Webster, the plain and ordinary meaning of the word give is to put into possession of another for his or her use, or to cause one to have or receive.
So what about Section 187C that prescribes the manner in which notice is to be given?
Well, Section 187C is a general statute that applies to insurance policies in general in the state of Massachusetts. Yeah. That is across the board for cancellation of all insurance policies. It's a general statute.
Right.
Section 65B is a specific statute which details the protocol, the proper way to cancel an assigned risk pool policy.
I understand that it's a specific manner of canceling an assigned risk policy, but why ought we not to construe the requirement to give notice under 65B in accordance with the provision of 187C that prescribes the manner in which notice shall be given?
Because it's a conflict between the burdens of proof between the two statutes. 187C requires only proof of mailing, that you hand a piece of mail over to a United States Postal Service worker. They stamp it with a certificate of mailing, which shows only that the United States Postal Service took possession of the mailing. It has no bearing on whether that piece of mailing was delivered, and certainly no proof of whether it was received. In fact, it really doesn't even show that the piece of mailing was entered into general mail circulation. It's simply
but as your brother points out, at the time that 65B was enacted, the legislature surely was aware of the long-established mailbox rule. And
yes.
They have demonstrated the capacity to establish more particular requirements for notice when they need to.
And they did that exactly. They did exactly that in their enactment of Section 65B, especially in the 1991 reforms, which is when this current version of Section 65B was enacted.
I want to ask you about a statement that you made in your brief on page 19 that suggests that that 187C requires certified mail.
Yes, Your Honor.
I looked at 187C and I didn't see it to require certified mail. Maybe I'm missing the relevant provision.
Well, if you take a look at section 187C as interpreted by the reviewing board in a number of cases and by the appeals court, they look at 187C and section 65B in conjunction, and they determine.
You're stating that as consistent with the board's requirement. We got sidetracked before. You had talked about Armstrong's case, Cummings' case. In each of those cases that we covered, we were able to identify respects in which the issue was not fully joined. So and Pillman did not involve this question either. It simply included as a comment or as an observation without further comment that the board takes this position. What, other than the board's decisions itself, which of course are subject to our review, what case is it that you have that suggests that this question has already been settled law?
Well, all of those cases that I cited, to Cummings, Pillman's, and Visco's that were at the appeals court, while you're correct in stating that they did not, they weren't as focused on the question that we are today. They do cite favorably to all of those reviewing board cases and the substantial deference that this court gives to
certainly we have a principle of deference. I don't know that to say that they cite favorably to the board's position. The issue wasn't raised. We have I think a fairly steadfast practice of not deciding questions that aren't raised by the case in front of us.
Yes, Your Honor. In Pillman's case, which addressed, well, it was focused on a voluntary policy. The appeals court did state, in cases involving assigned risk policies, the board construing section 65B requires that the employer receive the cancellation notice. Again, that's not the central finding of that case. I understand your question.
It's not a holding. It's simply a comment. It's an observation, but not a holding.
Yes, Your Honor. And what I'm asking you to do here today is to adhere to that that dicta from Pillman's case that provides substantial deference to the reviewing board's interpretation of section 65B, which requires proof of receipt. I think one of the major distinctions in this case that I think this court needs to really focus on is there's a very big difference between an assigned risk pool policy case and a voluntary policy case. And the cancellation protocols are different for each one. Voluntary is governed by section 63. Assigned risk is governed by section 65B. Now, assigned risk pool policy cases, the assigned risk pool itself is a market of last resort for comp insurance in the state. Employers initially go out to the voluntary market and try to buy policies. And where they cannot do so, they then apply to the assigned risk pool. The assigned risk pool employments are there for these high risk employments, catastrophic case, the very high danger employments or employers with poor injury track records, things of that nature. They can't get a voluntary policy, so they go to the assigned risk policy or assigned risk pool, and the risk is spread out. Because the risk of claims and the value of these claims is so high in the assigned risk pool, the board and the legislature, when they enacted section 65B's current version in 1991, they made the requirements for cancellation more stringent because it's designed to minimize the amount of uninsured employers in the state. If this panel agrees with ACE's argument that all you need to do to cancel an assigned risk policy is put it in the mail, you'd be controverting section 65B's requirement of receipt and the purpose behind that statute, which is to—
I guess I'd like to hear your response to Mr. Harris's argument that the legislature was aware of the mailbox rule when it enacted 65B. If it wanted to impose a requirement on the insurer to prove receipt, they could have written that into the statute. They've done so in other places. They could have written into 187C or into 65B the requirement that notice in this case be given by certified mail return receipt requested. They did not.
Well, that language would be superfluous, respectfully, Your Honor. Section 65B, the way it is written, does have a receipt requirement. Both
Yes,
in
but in the face of the mailbox rule, receipt in any number of other settings where receipt is also established as a criterion, the mailbox rule supplies the presumption of receipt, and then it becomes a question of fact for proof by the insured that despite the presumption, they did not in fact receive the notice.
Yes, but the mailbox rule is an artificial presumption created by common law. And Section 65B is a statute enacted by the legislature. And it requires both you shall give to the insured, which is receipt, and there's the 10-day objection period, which is conditioned upon receipt by the insured. That statute rules over a common law presumption. Statutory law supersedes common law. And the 10-day objection period cannot be overstated. That 10-day objection period written into Section 65B is conditioned upon receipt by the insured. The plain language of the statute says that 10-day period does not begin until receipt by the insured. So if a condition precedent to the 10-day waiting period is receipt, then that necessarily means a condition precedent to the effective termination under Section 65B is also conditioned upon receipt. And that
what would happen in a case in the following situation? The insured, it's an assigned policy. The insured sends out a notice of cancellation by certified mail, return receipt requested. And the insured in that case deliberately avoids signing for that notice.
if they deliberately avoided signing the green card?
Is that, yes, how is the insurer capable of canceling such a policy?
By dragging them into the hearing and having them testify. And then it's a credibility determination by the judge whether they refuse the receipt or not. Having the green card is certainly the most...
Would you say that the insured in that case had given the notice that was required and would be able to prove receipt by just the fact that a green card, a certified mailing had been made?
No, not unless it's signed by the insured and returned to them.
Okay, so essentially, as I understand it, your argument is that proof of actual receipt is going to be required no matter what the insurer has done in terms of effectuating notice.
Yes, proof of actual receipt. Which
and the notice and you say that this is required by the plain language of section 65B. So I'd like you to just, if you don't mind, tell me exactly which language you say requires that proof.
Well, there's two sentences in section 65B, which...
Well, I'm looking for a term actual, proof of actual receipt.
Shall give, the plain ordinary meaning of shall give is to, you must...
Shall give notice, give notice.
Yes, must put into the possession of another, not put into possession of the United States.
Well, it doesn't say that. I'm asking about the statutory language. You're relying on the words shall give notice in writing?
In conjunction with the further language, receipt by the insured, which is that part of the 10-day objection period. Since
Okay,
that is triggered.
All right.
That's triggered by the 10-day, or by receipt by the insured. And I see that my time is up. Not sure how we're going to handle the second case, but I will rest on my brief for now.
Well, I think unless there's something else that requires separate argument in the other case, I think we've joined the same issue. Correct?
No further argument from me, Your Honor.
Could I just ask one question, Mr. Martin, which is that you have a request for attorney's fees. What is that based on? Is that statutory fees?
Yes, section 13A fees, MGL 152, section 13A.
Thank you.
All right. In that case,
I'm sorry, Your Honor, which I believe the fees only applies to the claimant's, the employee's attorney. I believe Mr. Melendez would be entitled to a fee. I don't believe Mr. Martin is entitled to a fee on the statute.
All right. That concludes the argument then, and concludes our session. I want to thank you both for your arguments. The case is submitted.
Thank you.